Patricia Van Haren, family law attorney. What are the 5 things you must know about stock options in a divorce? Number 1, in some cases, stock options will be deemed to be a community property asset and will be handled in the property part of your divorce. The characterization of that particular stock option is going to be determined by the purpose of the plan. Is it an RSU? And also the facts of each case. In many cases, though, the stock options will be divided as property, giving both parties access to funds for their own use. Number 2, in other cases, stock options will be considered to be compensation and will be used in spousal support and child support calculations and not in the property division. Number 3, the courts have various rules on how to value and divide the stock options. It is imperative that you have the right team of experts advocating for your share of the stock options. Number 4, some courts may use what's called a time rule formula to allocate community and separate property interests in stock options. So those cases may apply to options that were granted during the marriage, but can't be exercised until after the date of separation. Other courts may use what's called an apportionment formula. And in that situation, the courts will use the value of the options by using a formula which determines which stocks are community, which are separate. And the spouse that holds the options in their name will be given a credit against any possible tax liabilities, as some stocks can't be transferred to the name of the other spouse. Number 5. In calculating the division of stock options, courts are going to need to look at whether the stock can be assigned to one spouse, whether they are vested, if they're not vested, and whether they're given to induce somebody to continue working there or to be used as a bonus for past employment. I had a case against an attorney who was not knowledgeable about the division of stock options and the tax issues related to them. Her arguments ended up costing her client more money in attorney fees than the value of the stock options in the first place. I had educated myself on the type of options that they were. I retained a qualified expert in stock options, and they proposed how those should be divided and what tax basis should be used. The court ordered that the options were to be divided as recommended by my expert, and they ruled that the formula was appropriate given the tax implications for my client. If you or your spouse have stock options, make sure that you have the right team so that they can save you money by dividing them properly. If you have any questions about stock options, shoot us over an email or give us a call.